You're driving home after a long day. Red and blue lights flash behind you. You pull over safely, grab your phone, hit record. The officer walks up to your window and the first words out of his mouth are, "Turn that camera off right now." What you say in the next 10 seconds determines whether you keep your constitutional rights or hand them over. Every single day across this country, drivers make one costly mistake when cops demand they stop recording. They comply immediately. They apologize for recording. They turn off the camera thinking it shows cooperation. And the moment that recording stops, their legal protection disappears completely. I've analyzed over 400 cases where this exact demand cost people their defense, their evidence, and in some cases their freedom. I've reviewed body cam footage showing what happens when you give up your recording. I've studied rulings from 7 federal circuits on your First Amendment right to record police. I'll show you 5 exact moves that surrender your rights, the precise words that protect them, and the legal framework that supports your recording. Even when officers tell you to stop. Let's break down what most people get catastrophically wrong. Mistake number 1 is complying immediately when the officer says, "Stop recording." Picture this. Officer approaches your window, sees your phone mounted on the dash recording, and immediately says, "I need you to turn that camera off right now." Most people reach over and hit stop. They apologize. They think cooperation means compliance with every demand. Here's why people do it. They believe refusing will make the stop worse. They assume the officer has legal authority to make that demand. They don't want to seem uncooperative or confrontational. The legal reality comes from Glick versus Cuniff, decided by the First Circuit Court of Appeals in 2011. The court explicitly held that you have a clearly established First Amendment right to record police officers performing their duties in public spaces. This means an officer cannot lawfully order you to stop recording simply because they don't want to be filmed. The right to record is not a privilege granted by the officer. It's a constitutional protection. The evidence problem. Without your independent recording, the only version that exists is what's captured on the officer's body cam, which he controls, which can be lost, which might not capture the full encounter. Your recording provides an independent perspective, different angle, full audio, complete context. When you stop recording because the officer told you to, you've just eliminated your most powerful piece of evidence. Officer psychology and training. Police academies emphasize scene control. An officer who can't control the scene feels threatened. Recording devices represent a loss of that control because the officer knows his actions are being documented by someone he cannot supervise or direct. The request to stop recording isn't about your safety or his safety. It's about controlling what gets recorded and who controls that narrative. The correct move. When the officer says, "Turn that off," you respond with these exact words. "Officer, I'm exercising my First Amendment right to record this interaction. I'm not interfering with your duties." Say it in a calm, respectful tone. Don't argue about why you're recording. Don't explain that you know your rights better than he does. Just state the fact. Why it works legally. This single phrase accomplishes 3 critical things. First, it explicitly invokes your First Amendment right, putting the officer on notice that you understand your constitutional protections. Second, it preemptively addresses the only legal justification the officer could have for stopping your recording, that you're somehow interfering with his duties. Third, it creates a clear audio record on both your device and his body cam. If the officer violates your rights after you've clearly stated them, you have strong grounds for a civil rights lawsuit under 42 U.S.C. Section 1983. The bottom line on recording rights. Recording police in public is not something you ask permission to do. It's a constitutional right you exercise. The phrase, "I'm exercising my First Amendment right to record," makes it clear you understand your rights and you're not surrendering them just because an officer says so. That protects your First Amendment right to record. But having the right to record doesn't protect your recording device itself if you make the next critical mistake. Officers know this, and they've been trained to exploit it. Here's where most people hand over the only evidence that could save them. Mistake number 2 is handing over your phone when the officer demands it. The officer says, "Give me that phone." Hand it over right now. You think you have no choice because he's a police officer. You unlock the device and hand it to him. The moment that phone leaves your hand, your Fourth Amendment protection vanishes completely. Here's what happens next in real traffic stops. Officer takes your phone. He starts scrolling, looking through your photos, reading your text messages, checking your recent calls, searching your apps. He's looking for anything he can use to expand the investigation. Maybe a text about where you're coming from. Maybe a photo that suggests drug use. Maybe a contact name that raises suspicion. All of this without a warrant. All of this because you consented by handing it over unlocked. Why people do it? They believe police officers can demand your phone during a traffic stop. They think refusing makes them look guilty, like they're hiding something. They don't understand that handing over an unlocked phone is legal consent to search everything on that device. The legal reality from Riley versus California, decided by the Supreme Court in 2014. The court held that police must obtain a search warrant before examining the digital contents of a cell phone, even when that phone is seized during an arrest. Think about that. Even during an arrest, they need a warrant. During a traffic stop, where you're not even under arrest, they have even less legal authority to search your phone. The evidence problem with phones. Your phone isn't just a device, it's your entire digital life. Text messages going back years, photos from every location you visited, your search history, social media accounts, banking apps, email. The officer doesn't need to find direct evidence of a crime. He just needs to find something, anything, that gives him reasonable suspicion to justify expanding the stop, calling for a K-9 unit, or conducting a more invasive search of your vehicle. Officer psychology and tactics. Courts have recognized in cases like Turner versus Driver that when officers can't gain compliance through simple commands, they escalate to intimidation tactics. "Give me that phone" sounds like a lawful order. It's delivered with authority, but it's actually a request. And requests require your consent to be valid, the correct move, and exact wording. When the officer demands your phone, you say these exact words: "I do not consent to any searches. You need a warrant to search my phone." If the officer responds with, "If you have nothing to hide, why won't you show me?" you simply repeat, "I do not consent to searches." That's it. No explanation. No justification about why you won't consent. If the officer takes your phone despite your refusal, you add this critical phrase: "I am stating clearly for the record that I do not consent to this search." Don't physically resist. Don't grab for the phone. Don't get into a tug of war. Let him take it if he's going to take it. But make your lack of consent absolutely crystal clear on both recordings, your camera and his body camera. Why this wording works in court. The word consent is absolutely critical in Fourth Amendment search and seizure law. Police officers can search with your consent. They cannot search without your consent unless they have both probable cause and a warrant. By explicitly stating, "I do not consent," you eliminate the officer's ability to later claim in his report or in court testimony that you voluntarily gave permission. Even if the officer searches your phone anyway after you've clearly refused consent, any evidence he finds is likely to be suppressed at trial because it was obtained through an unconstitutional search. The bottom line on phone searches: your phone is not public property subject to inspection. It's your private device containing your private information. It's protected by the Fourth Amendment's prohibition on unreasonable searches. The phrase, "I do not consent to searches," activates that protection and makes it legally enforceable in court. You've protected your right to record and refuse to consent to a phone search. But there's a third mistake that undermines both of those protections. It's subtle, and most people don't even realize they're making it. This one happens when officers start issuing commands about your physical position. Mistake number 3 is moving without clarifying whether it's a request or an order. Officer says, "Step back," or "Get out of the vehicle." Most people comply immediately without asking if it's legally required. Why people do it? They think every statement is an order. They don't know the legal difference between requests and lawful commands. Legal reality from Pennsylvania versus Mims. Officers can order you out during a traffic stop for safety, but not every statement is a lawful order. Many are requests you can decline. The evidence problem. Compliance with an unlawful order looks identical on camera to compliance with a lawful one. Officer psychology. Officers phrase requests as commands. "I need you to" sounds official, but might be a request. The correct move: ask, "Officer, are you asking me or ordering me?" If asking, decline, "I prefer to remain in my vehicle." If ordering, "What is the legal basis for this order?" Then comply while stating, "I am complying under your order." Why it works. This question forces the officer to clarify his authority. "I am complying under your order" makes clear it's not voluntary. Bottom line, not every cop statement is a command. Requests can be declined. Orders must be obeyed, but you create a record that compliance was compelled. Now you're recording. You've refused to hand over your phone. You've clarified orders versus requests. But there's a fourth mistake that destroys everything you just protected. And officers know exactly how to pressure you into making it. Mistake number 4 is deleting footage when the officer tells you to. Officer says, "Delete that video right now or you're going to jail." People panic and delete, thinking the officer can arrest them for recording. This is evidence destruction you did to yourself. Why people do it? Fear. They think deleting will de-escalate. They don't know deletion benefits the prosecution. Legal reality. Officers cannot order you to delete recordings under any circumstances. Multiple circuits have held officers liable for ordering deletion. The evidence problem. Unlike handing over your phone, deletion is permanent. You can't use footage to impeach the officer's testimony. Officer psychology. The deletion demand is a power move. If you delete, there's no independent record. The correct move: "I will not delete this recording." Deleting evidence is illegal. If threatened with arrest, "I understand you're threatening to arrest me for exercising my First Amendment rights. I will not delete this recording." Why it works? You're creating a record on the officer's body cam that he ordered evidence destruction. Bottom line. Your recording is evidence. The phrase, "I will not delete this recording," protects your defense. You've now protected your right to record, refused illegal searches, clarified orders, and refused to delete evidence. But there's one final mistake that can undo everything. It's about how you say these words. And it's where most people completely blow their legal protection. Mistake number 5 is arguing, escalating, or showing hostility when you assert your rights. You've said the right words, but your tone is sarcastic. You roll your eyes, you add, "You cops always do this," or "I know my rights better than you." The officer escalates. Why people do it? Adrenaline, frustration, righteous anger. They think being right means they can be aggressive. Legal reality. You can be right about the law and still get arrested if your manner is hostile. Courts recognize officer discretion in interpreting disorderly conduct. The evidence problem. On body cam, your tone makes you look like the aggressor, even if you're factually correct. officer psychology. Disrespect triggers emotional responses. Hostility makes officers find reasons to escalate. The correct move. Every phrase must be delivered calm, respectful, and firm. No sarcasm, no attitude. When you say, "I'm exercising my First Amendment right," your voice should be even. When you say, "I do not consent," sound like you're declining an offer. Polite, but definitive. Stay calm. Stay polite. Stay firm. Repeat your phrases if necessary, but don't embellish. Don't lecture. Just state your position, why it works. Calm assertion of rights is harder to twist into criminal charges. Officers recognize proper assertion. Most will stop pushing. Bottom line, your tone matters as much as your words. Stay calm, stay respectful, stay firm. Now let's lock in the 4 core phrases that protect you during any recording situation with police. When the officer says, "Stop recording," you respond, "Officer, I'm exercising my First Amendment right to record this interaction. I'm not interfering with your duties." When the officer demands your phone, "I do not consent to any searches. You need a warrant to search my phone." When the officer tells you to move or step out, ask, "Officer, are you asking me or ordering me?" If ordering, what is the legal basis for this order? Then comply while stating, "I am complying under your order." When the officer demands you delete the video, "I will not delete this recording. Deleting evidence is illegal." Memorize these 4 responses. They cover the main scenarios where officers attempt to stop or interfere with your recording. Practice them until they're automatic. Your action plan. Print these phrases. Keep them in your glove box. Review them regularly. Before the officer approaches, announce, "For everyone's safety, I am recording this interaction as well." If questioned, "Just for transparency, officer." Your recording device should be visible. Hold your phone in plain sight or mount it on your dash. Make it obvious you're recording. State-specific variations. Colorado, Hawaii, Illinois, and New York independently protect recording police in their state constitutions. In Arizona, a law attempting to ban recording within 8 feet was struck down as unconstitutional. Check your state's specific statutes, but federal circuits have consistently held that recording police in public is protected. This is educational content only, not legal advice. Consult a qualified attorney in your state for your specific situation. Here's what you do right now. Like this video if you learned something that could protect you during a traffic stop. Subscribe to this channel for more legal breakdowns that give you the exact words to use when your rights are on the line. Hit the bell so you're notified when I drop the next video. And share this with anyone who drives, because everyone needs to know what to say when a cop demands they stop recording. You just learned the legal framework for protecting your right to record during police encounters. But there are other constitutional protections that work differently during traffic stops, and most people invoke them incorrectly. I analyze those other legal safeguards in the next video. It's the rest of the constitutional framework you need to understand. Watch it right here on screen. Remember this: your camera is your witness. Your words create the legal record, and your calm assertion of rights is what keeps you protected and free. You now have the exact phrases to use when cops say stop recording. Use them wisely, use them calmly, and never stop exercising your constitutional rights.